Zachary Conley versus Athena Couch.
Court will note the appearance of Mr. Kelly on behalf of the plaintiff, defendant appearing in pro per. This matter is before the court on the defendant's motion. In this matter, it appears from the motion that it's for reconsideration. Ms. Couch, you can proceed with your motion.
Okay. I have filed this motion for reconsideration of the parenting time given to the plaintiff. I don't believe the current order is in the best interest of the minor children, Amelia Margaret Conley and Evelyn Ann Conley. The plaintiff and his family's primary concern is money and control. In an effort to avoid paying child support, attorney Michael Kelly stated the plaintiff wanted primary custody of the children who have been under my supervision and care their entire life. It is apart from weekend visitation with grandparents. I wholeheartedly and unconditionally love my children, and I made it abundantly clear I did not want to put my children in daycare. I believe that having a positive parental figure is important for the development of children ages infant to preschool, to encourage an appropriate, safe, and consistent environment. I have stated in this motion how I aspire to feed the minor children healthy foods, more specifically nourishment for their bodies. Both of my children are in the 90th percentile for their height, and no one has mentioned how smart the children are. I, the defendant, have been reading books to the children since they were a week old, and we read books before bedtime and before nap time. They also know an abundance of nursery rhymes and songs. Excuse me. The minor children who are 2 years and 8 months old know the alphabet, numbers 1 through 15, all their shapes and colors. They also can say over 200 words, almost speak full sentences, and according to pbs.org, my children can read. Excuse me. You need to go play, please. I do think it's important to lead by example, and though my morals were in question due to lack of up-to-date tags on my vehicle, I am a good person. I opened doors for others, and most are greeted with a smile. I taught the minor children to say please, thank you, excuse me, and to cover their mouth when sneezing or coughing, and we do not judge others. If you are kind, kindness is reciprocated. I even, excuse me, you need to back up and go play. Excuse me. No. I'm sorry. No, you cannot be in here. You need to go play. I'm sorry. Honey, no. I'm sorry.
Anything else, Couch?
Yes, I'm sorry. I had lost my place. We do not judge others. And even then we do greet others with understanding. The plaintiff's character is in question, and I have asked the plaintiff for an explanation regarding him watching videos of children peeing in diapers, and even more so the videos of children and babies he was watching have enemas done to them, all of which he had no response or flat out lies. I can prove, I have evidence. I'm a mess. I apologize. If the plaintiff's family was also made aware of the plaintiff's fetish of diapers, because quite frankly, it was appalling and I was concerned. Lori Putnam, the plaintiff's mother, stated on June 18th of 2022 that the plaintiff had started stealing his half-brother's diapers to use at 15, and that she consulted her husband and it wasn't an issue. She then consoled me and offered to give me a hug, and then tell the plaintiff the next morning within earshot of where I was reading to the children that I, the defendant, was the problem. This is just one of the, stop please, stop. This is just one of the many instances that I have felt psychologically manipulated by the, stop please, stop honey, by the plaintiff's family. It is my belief that the plaintiff and his family's intent was to manipulate the court and in altering information, and therefore putting the plaintiff in a fatherly light. Unfortunately, this is contrary to what I have witnessed, and the plaintiff has had maniacal episodes where he would run through the house house, shaking his head with his tongue out, and he would crawl across the floor. He has crawled across the floor of the minor children's bedroom, crouching and staring at me. As I stated in the motion, he frequently bangs his head into a steering wheel. And when asked why he was doing this, the plaintiff expressed to me that he has a hard head and that he used to bang his head into his school. Stop, please. Honey, go play for a moment. I cannot. Okay.
Ma'am, the kids should not be hearing all this. You're gonna have to remove them from the room, please.
I don't have another option.
Well, you go into a different room. There's gotta be another room you can go into to have this heard. If not another room, go outside or something.
Okay. Okay. I'm very sorry. I do apologize for being so all over the place. Okay. Plaintiff attended Lakeview schools, and it does surprise me that no administrative intervention was done with the plaintiff's parents. I do believe that plaintiff and his family are not positive, kind-hearted people who have the children's best interest in mind. On the contrary, malicious, manipulative, and falsifiers. I am here pleading you to take immediate notice of how the plaintiff's behavior is dangerous and potentially damaging to the minor children, Amelia Margaret Conley and Evelyn Ann Conley. It is imperative that the visitation between plaintiff and the minor children be supervised. Furthermore, no overnight visitations. And I am extending an alternative option for parenting time. Monday, 4 to 8 p.m., Wednesday, 4 to 8 p.m., and Saturday, 11 a.m. to 9 p.m. And that's everything.
Okay, anything else?
No.
Okay, Mr. Kelly. I have reviewed your answer.
Your Honor, then you're aware of the burden that must be carried. Palpable error has not been shown this morning, Your Honor. These are the same issues that have been brought up time and time again throughout this case. We had a hearing, evidence was presented, no palpable error has been shown this morning. Your Honor, we'd request the motion be denied. We'd also request attorney's fees for having to respond to this motion because it is not well based in law or fact, and is devoid of arguable legal merit. Thank you.
Thank you. Well, the court notes in reviewing all the pleadings and especially the defendant's motion that she does not allege or argue anything that was not previously addressed. There's no new information which would cause the court to change the order, and she has not established palpable error whereby the court was misled when the court made a ruling in this matter previously. As a result, the court will deny the motion. Mr. Kelly, you can do an order denying the motion submitted under 7-day. The court is not going to award any attorney fees at this time, but the court will consider that in the future in the event that the issues are in fact brought up again. So, Mr. Kelly, you can prepare the order, submit it, and that will conclude the case. You're free to go. Have a good day.
Thank you, Your Honor.
This is Avery Miller versus Miranda Finley.
Court will note that this matter is before the court on the defendant's emergency motion for an ex parte custody order in this matter. Ma'am, you've alleged a number of things as far as some pending parental kidnapping charges, et cetera, but you've not alleged what happened as a result of those charges. Have the charges concluded in any way?
I haven't heard anything, no.
Okay. Go ahead with your motion. Anything else?
This wasn't my motion. This was his motion.
Okay, I did say it was defendant's motion. I'm sorry, ma'am.
It's okay.
Mr. Miller, go ahead with your motion.
Your Honor, my name is Avery Miller Graham. I'm the father of Alea, Amira, and Akira Miller Graham, the minor children involved in this matter. I'm appearing before the court today in ex parte proceeding to seek immediate relief due to Miranda Finley violating the current parenting time order and engaging in abusive conduct towards our middle child, Amira Miller Graham. I respectfully request that the court issue temporary relief to protect the minor children's safety and to enforce my parenting time rights. The court has jurisdiction over this matter pursuant to MCL 722.27, which governs custody and parenting time in Michigan, and the venue is proper as Calhoun County is where the minor children reside. The parties were previously ordered to follow a parenting time schedule established by the court. However, Miranda has violated this order repeatedly by withholding my parenting time, thinking she is above the court, picking and choosing when I can see my children, and not allowing me to see my children on my weekends or any weekend at all. In addition to violation of the parenting time order, I have serious concerns regarding the safety and well-being of my daughters. Miranda Finley has engaged in abusive conduct towards Avery Miller, including choking, fighting, bullying, taking verbal abuse, taking minor child's phone so she can't call for help. As a result of this abuse, my children do not wish to continue to live with Miranda Finley, are constantly depressed, scared, out of fear of Miss Finley. There's also an ongoing CPS case with Miranda. She hasn't been taking the youngest child, Akira Miller, to school because Miranda was banned from Akira's school due to hysterical, vicious behavior on 4 separate occasions. I request for temporary relief from the court on an emergency basis in order to prevent further harm to the minor children and to enforce parenting time rights. An order requiring Miranda Finley to immediately comply with the parenting time schedule as set forth by the court, temporary custody of the minor child, or at a minimum supervised parenting time until further proceedings can be scheduled. An order directing Miranda Finley to immediately return the minor child's phone, as it is a reasonable expectation for the child to have access to communication with both parents. A temporary protection order to ensure the safety of the minor child if necessary. An order directing Child Protective Services to immediately investigate these allegations of abuse and file a report with the court.
Okay, anything else, sir?
No, that's it.
Okay, well, I will tell you, if CPS if there's a basis, they will investigate and then they will file a report at the conclusion basically of 30 days. So that's if they find that there's any basis for that. So I don't need to order them to do something that they're required to do in any event. What happens is the court will enforce the orders of the court. So if you're not getting parenting time, then the court will enforce that, and that parenting time will be ordered. If a party doesn't comply, they risk going to jail if they don't comply with parenting time. Ma'am, anything else you'd like to say before we conclude?
Yes, sir. So, Avery Miller has brainwashed my 14-year-old into believing that she's not safe. Her phone got took due to her failing grades, not because of her safety. I had recently moved back to Calhoun County, and my kids were going to Lakeview School, but I pulled them out of Lakeview School due to Avery going up there with CPS and acting like he was CPS and interrogating my 10-year-old daughter without my permission regarding that he has no parenting time, he's not on the birth certificate, and he's not on any paperwork. So I'm in the process of transferring their schools due to the safety of my concern for my kids, because he wasn't even supposed to know where my kids went to school at, because since he literally did this as soon as I moved back down here. He has not tried to get my kids since we went to court. He was able to talk to my girls on their own phones whenever he wanted to. He's been riding past my grandma's house harassing me. I just got this court order, so I haven't been able to go down to the courts to file a protection order against him, because I have text messages and everything that I need to send to the court of him threatening me, him calling, like, it's always this. He's always threatening me. He's harassing me. I let him get his kids when he wants to. I let his family get the kids when they want to, until it comes to this. He literally went to my daughter's school and interrogated her, and the school thought that he worked with CPS. So I had an issue with the principal about it, and they put a no trespassing on me because I went up to the school because he pretended that he worked with CPS.
Okay, well, ma'am, you say that he has nothing in this matter that gives him any rights, but the court does note that there was an order for custody and parenting time back on March 22nd or 21st, 2022. So how are you saying that there's no paperwork
His parenting time was taken because of that.
taken?
Yes.
Your Honor, can I say something?
Go ahead, sir.
I never posed as a CPS worker. I had to meet the CPS worker Nikki Booker that was on the case. I had to meet her at the school because of several failed attempts to meet with Miranda to interrogate, as she calls it, the kids, the minor children. She was dodging Nikki Booker, so I said that I would meet her at the school. Nikki showed them her credentials and everything. I can't pose as a CPS worker and not show them any credentials, and they let me talk to a minor child.
Okay.
And she's right as far as that goes. Like, I'm not able to get any records from the school because the records would indicate that Akira has only been in school maybe 2 weeks, and the school year started months ago.
Because she was going to Lansing school before we moved down here.
Okay, let me
Can I
see.
say something else as well before you're done?
Just a minute, ma'am.
I don't understand why we got to keep going through this and our kids.
Ma'am, just a minute. Okay, I wanted to get back to the order, so I'm pulling the order up. Okay, this is the order that was dated March 21, 2022. It did provide for a suspension of parenting time pending those parental kidnapping charges. And you're saying they haven't been resolved at this point?
No.
Your Honor, they have been resolved. They lessened the charge because it was never me just like taking or kidnapping the kids. It was me not sending them back to the mom on as the court order stated. I was supposed to send them back, and I never sent them back. So that was violating the court order, and it started out a parental kidnapping, but they lessened the charge, and I ended up getting probation and did probation for it.
Okay. Well,
In Kalamazoo County.
what you're gonna have to do, sir, is that order is still in place until it's changed. So as it relates to parenting time, you're gonna have to file a motion for parenting time in this matter, and you're gonna have to set forth the basis for doing it. And then the court will entertain it at that point, but this is a different motion. You're seeking a motion for ex parte custody. Custody is different than parenting time. Anything else, ma'am, before we conclude?
Yes, two things. The CPS case was closed due to no findings, and I wasn't dodging the CPS worker. I got in touch with her, and I also have text messages proving that I was trying to get in touch with her several times, and she canceled on me several times.
Okay. Well, what the court notes in this matter is that the defendant does file the motion in very conclusory terms. There's no allegations of fact on which the court can determine if there is in fact probable cause or change in circumstances sufficient to modify custody. And the request is for modification of custody. And as a result, there's no basis for the court to do that. So I'm going to deny the motion at this time. Ma'am, you're going to have to prepare an order denying the motion. And otherwise, sir, if you wish to have parenting time, you'll have to file a motion for that and set forth facts on which the court should base the finding. So court will conclude this matter. You're free to go. Have a good day.
Thank you.
Jean Concannon versus Hans Rogers Jr.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on plaintiff's motion to modify custody and parenting time. Ms. McNiff.
Your Honor, these parties have children who are ages 12 and 14, and my client in the past has struggled with substance abuse, particularly alcohol. And in 2020, as a result of that, dad was awarded custody of the children. Mom has subsequently gotten sober, been sober for a period of time, is now working as an addiction counselor. And dad has fallen into the problem of having some substance abuse issues, particularly with methamphetamine. In fact, he's on probation currently for that. Dad also is currently having struggles with his job, has indicated that he doesn't have the funds to feed the children. And as a result, mom has had the children in her care and custody. And the goal here isn't to change physical custody on a permanent basis. The goal is to change physical custody on a temporary basis to give dad the same chance mom had to go to rehabilitation, to become sober again, and to be able to regain the stability that he had in the past. So we're asking for a temporary change of physical custody and parenting time as the parties agreed. These parties have been able to agree on parenting time when mom had her struggles. As she recovered and as she became more stable and as she regained sobriety, dad agreed that she would have the kids with her half the time, which is what the status quo was until dad started to struggle. So we think a temporary period where dad can work on himself would be appropriate.
Okay, thank you. Are you Mr. Rogers?
Yes, yes, I am, sir. Can you hear me?
Yes.
Okay, good.
What's your response to the motion, sir?
So I only got to hear half of it because I was struggling to make my phone work. Thank you for allowing me the opportunity to speak. If I am understanding you, first of all, I would like to say that I am not only in favor of Jean having her parental rights restored. I believe that was a mistake and one that I regret that I acquiesced to. And not only am I in favor of it, but I would sign the witness. She's done wonderful. And I believe that she never deserved to have it happen in the first place. And I have been very regretful about that day for a long time. In answering what is happening with me, I've had a lot of issues with job, finances, and everything in that paperwork is correct. I am doing better with my recovery. I am on probation with Agent Carrie Moore in Calhoun County. I have been passing all of her testing. So that is one version of where you can monitor what I'm saying is correct. I'm in outpatient services with a therapist, and I go to meetings. I'm still employed, and my financial situation has improved. However, I am still struggling to the point to where I would agree that a modification of parenting orders to ensure the safety of our children would be appropriate.
Okay. Well, what would you agree to at this point, sir, so the court knows?
Do you mean in regards to parenting, or what do you mean specifically? I'm sorry.
Either. You said that you want her to have the
I
rights.
can't hear you.
You say that you want her parental rights restored.
Can you hear me? Because your audio just fully went out.
Okay.
Now I can hear you.
Okay. You said that you want her parental rights restored, and then you said that she could have parenting time. So I'm trying to get some specifics.
Okay.
What are you agreeing to as far as the restoration of her parenting time?
Of her parenting time? I'm so sorry.
Yes.
I'm confused. I
Yes,
believe she should have 50-50 custody. She should have every right given back to her that she as a mother has naturally.
Okay. So you're agreeing to 50-50 custody, and what's your agreement as it relates to parenting time?
Okay, I apologize. I'm not fully, if that would be 50-50, but if you're asking in regards to the current situation with the attorney brought up with my struggles, is that what you mean?
No, I'm
Okay.
just asking, what are you agreeing with parenting time? And you're saying
50-50. Yes, sir.
Ms. McNiff, does that take care of your issues at this point or not?
I think we were looking for parenting time as agreed. That's what the parties have been working off since 2020. And they've been able to make adjustments in a really amazing way when either one of them have had struggles. And I know the court doesn't usually like as agreed, but given this particular situation, I think it might be appropriate.
Well, why don't you put it in there that it would be 50-50, specifically as agreed between the parties, and then we have that in there in the event that there became an issue in the future.
I think that makes sense, Your Honor.
Okay. Sir, you understand with agreeing to this that you're going to be bound by this. You understand that?
Not only do I understand that, I think it's the way it should happen. I
Okay.
fully agree with it.
That's fine. I just have to establish this for the record, sir. That's all.
Yes, sir. Thank
Okay.
you, sir.
So, and do you believe that it is in the best interest of the minor children that the parties, that you have joint legal and joint physical custody and parenting time on 50-50 basis?
Yes, sir.
Okay. Okay, Ms. McNiff, then we'll let you prepare the order, and then you can acquire the income information as well. Sir, what you're going to have to do is submit your income information to Ms. McNiff so that she can calculate.
Your Honor, the parties have waived child support in
Okay.
the past, and it's my understanding that they want to continue to not have child support paid one to the other, that they're splitting costs in a way that's appropriate.
That's fine as long as they're not on public assistance.
And nobody's on public assistance.
Okay, then you can prepare that order, submit it to Mr. Rogers, let him approve it, and then submit it to the court.
Thank you.
Okay, so Mr. Rogers, you'll be getting something from Ms. McNiff, and if you sign that and send it in, then we'll be able to conclude the matter.
Yes, sir.
Alexis Torres versus Stephanie Torres.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Ms. Greenlee-Clore on behalf of the defendant. This matter is before the court on the defendant's motion to modify parenting time and child support, as well as to set aside the referee recommendation. Ms. Greenlee-Clore, go ahead.
Thank you. I'm going to rely mostly on my motions here. The defendant originally filed a motion to modify custody, which was kind of a misnomer because she still has, pursuant to the judgment of divorce that was never changed, she still has joint legal and joint physical custody. So when she filed the motion to modify custody, it was actually a motion to modify parenting time. So we are asking that the referee's recommendation be set aside because of that. But on top of that, we've also filed a brand new motion to specifically modify parenting time that we believe needs to be addressed in front of the referee. So we are hoping that both motions can go back in front of the referee to determine a change in circumstances and new parenting time. Thank you.
Okay, thank you. Ms. Reed?
Your Honor, the parties in this matter share one minor child, Nat Sebastian, and while the judgment of divorce does state that the parties share joint legal custody, physical custody is governed by the parenting time schedule. And in the original judgment of divorce, my client had primary physical custody and mom had parenting time alternating weekends from Thursday until Monday morning. That was subsequently changed due to a failure to exercise parenting time, and she currently has standard parenting time of alternating weekends, at least one midweek visit, and then alternating weeks during the summer. We state that the referee was correct in dismissing her original motion regarding custody, as moving from Lansing to Battle Creek is not proper cause or change in circumstance to modify custody. And we believe that since our defendant has filed a second motion and she's titled it parenting time, that is also a second motion to modify custody, as moving from alternating weekends to a week on, week off schedule is nothing short of a change in custody. So we're requesting that both of those motions be denied, and we're requesting attorney's fees of $875 for having to respond to a second motion for custody.
Okay. Ms. Greenlee-Clore, what are your thoughts on that? If you're seeking to move to a alternating week, isn't that a modification in custody as opposed to parenting time?
Our position is that the judgment of divorce, if you look at the judgment of divorce, page 2, the bottom of it says specifically that the parties share joint physical custody. And that was never changed by any subsequent order that I can find. Of course, the parenting time was modified, but that's because my client had to move to East Lansing. She's now back. So I think that I think we've got two pending motions. Her first motion was a motion to modify custody. We can certainly address that if the court deems that this is a custody issue, or we also have a pending motion to modify parenting time. So we can also address that as a parenting time issue as well. But either way, there has been a change in circumstances because my client has moved a significant distance to be back with the minor child. She's now about 10 minutes away from the child, whereas she was over an hour away before. So there has been a change in circumstances. Either way you want to look at this, and we do have both a custody and a parenting time motion pending. So I think it's appropriate to address it either way.
Okay, well, court looks at this as, take the parties for what it's worth, and obviously she had filed a petition for change in custody. The referee denied that. It did appear to be appropriate for the referee to do that, as the court does not find that, again, a move is a sufficient change of circumstances to meet the Vidvarka threshold in this matter. And obviously she's moved back, but it's only approximately an hour drive, so the court doesn't hold that to be very substantial either in this particular matter. And under Wright v. Shade, the court doesn't believe that there's sufficient basis at this time to modify parenting time. So what the court is going to do, the court will deny both of the motions. I'm not going to award any costs at this time, Ms. Reed, so you can prepare an order denying the motions and submit under 7 days. Okay, you're free to go. Have a good day.
Krista Trout Edwards versus Ivan Edwards.
Court will note the appearance of Ms. Capture on behalf of the plaintiff, Ms. Goodroom Garland on behalf of the defendant. This matter is before the court on the plaintiff's motion to require defendant to provide bond or security to ensure payment of child support and tuition. Ms. Capture, you can proceed.
Thank you, Judge. I have had an opportunity to review Ms. Goodroom's answer, and I don't want to go over in depth what was in our petition, as it speaks for itself. However, I wanted to speak specifically to the fact that Ms. Goodroom has stated on behalf of Mr. Edwards that plaintiff is simply seeking to not follow through with her financial obligations under the judgment of divorce. It's simply not true. The refinance has been completely approved. We filed our motion today simply in an attempt to secure child support and the other financial obligations that Mr. Edwards has to his child. There's been a substantial change in circumstances here with Mr. Edwards moving to Ireland. He was unable to secure employment here in the United States and has left and moved entirely back to Ireland. That is his home country. The issue becomes is that enforcement of a child support order in the event that Mr. Edwards does fail to follow his obligations is extremely difficult on the end of both the court and Ms. Edwards. So to be able to avoid that, security is warranted in this particular case. Mr. Edwards has not obtained employment. I believe he's trying to, however, he's not been successful. He's abandoned all parenting time. And yet Ms. Edwards is simply attempting to provide some kind of security in the event that Mr. Edwards does fail to follow through with his financial obligations. Specifically, Your Honor, we did do the calculations, and based on the UCSO as it is right now, as well as the other tuition requirements under the judgment of divorce, the total outstanding amount due, if this were not to change, would be around $55,000. The $45,000 bond that we're requesting is lower than that, obviously, and we're simply requesting that as security in the event that Mr. Edwards does not follow through with his support and other financial obligations under the judgment of divorce. This is warranted under Michigan statute. And further, Your Honor, we're not asking that that payment not be paid by the date of the judgment of divorce. It be paid, placed in security, and then released to Mr. Edwards after he can show the court that he does have employment. There is consistent payment that is continuing, and then the money can be released to him again. Thank you, Your Honor.
Okay. Ms. Goodroom Garland, go ahead.
Defendant is and continues to be current on his child support obligation, as well as his share of the minor child's Catholic tuition and schooling. He has never been in arrears. Defendant has continued to have parenting time with his daughter via their routine FaceTime calls. Mr. Edwards has relocated to Ireland in order to be able to provide for himself financially, as well as to continue to support his daughter. He has family there. He's a UK national, so he's able to work there and get health insurance there, and be able to provide a secure living situation for himself. And in addition to being able to in the future bring his daughter there for visits. He is living in an apartment on his parents' compound or land, and he's able to help and secure the assistance of his family. There is no reason to suggest to this court that Mr. Edwards would not be able to continue making his payments. He has continued to make his payments timely, and he has been unemployed in Michigan for quite some time. The court should note that Mr. Edwards did not seek to modify his child support obligation based on his employment. He wants and continues to provide support for his daughter, and he is seeking employment in Ireland and has some really good opportunities that he hopes that will come to fruition. In the meantime, he will continue to pay his child support and his daughter's his portion of his daughter's educational expenses as ordered by this court. He has never been late. There are no arrears. There's no reason at all for plaintiff to be seeking security and not pay Mr. Edwards his portion of the marital, his equity in the marital home. There's just no reasons, no grounds. Thank you, Your Honor.
Thank you. Ms. Capture, recognizing that he's current on his support obligation and current on the tuition, why would the court need to, again, maintain some security?
Your Honor, the crux of this is the fact that he lives in Ireland. Enforcing a UCSO in Ireland is extraordinarily difficult. A special tribunal would have to be created in order to get Irish, essentially what would be similar to a friend of the court personnel, to enforce enforce the Michigan court order there. These hoops would be extraordinarily difficult to jump through, not just for plaintiff, which would require, financial obligations in order to hire an attorney and support her claim in the event that Mr. Edwards did fail to follow through with his financial obligations. But also it would be overly burdensome on our court. This is simply, we're requesting some kind of security. We're not requesting that the payment not be paid. Ms. Edwards is stating specifically that she will pay the entire $45,000 due and owing. She's just requesting that it be placed in a bond to support her and the child. I understand that Ms. Goodrum has stated that Mr. Edwards gets regular parenting time. He does not. He gets some FaceTime on Saturdays. He has ultimately failed to provide proof of SoberLink. He's unfortunately an alcoholic who has not had face-to-face in-person parenting time. He lives in Ireland now. So, Your Honor, we've seen multiple failures under this judgment of divorce by Mr. Edwards, and we're requesting some kind of security to ensure that he does not fail in this particular facet of the judgment of divorce and child support order. Thank you.
Okay. Well, the court notes, and I look at this, and Ms. Capture, your own words say, in the event that he did fail to make payments, he has not done so at this time. He is current. He is current on both the support and the tuition. So notwithstanding whatever her fears may be, he has continued to pay, notwithstanding not being employed and not having income at this point. That evidence is at least to the court that he has a good faith attempt, good faith means, I guess you'd say, to get the matter continued to be paid. So the court doesn't see any reason at this point to require any surety or bond or anything at this point, as long as he's current if he should in fact become delinquent or something, then the court could review it at that time and require some sort of a bond. But at the current time, the court doesn't feel that it's warranted. Ms. Goodrum, Garland, I'll have you prepare an order stating I'm denying the motion, and you're free to go. Have a good day.
Thank you so much, Your Honor.
Yes, I have a working vehicle.
Okay. Do you have current insurance on it?
I do not.
How about current tags?
No,
Is that the vehicle you transport the children around in?
I do, but very little. We mostly stay at home into the store.
When the children were born, was Mr. Conley present at their birth?
He was.
Were the children delivered by C-section?
Yes,
Did he actually cut the umbilical cords?
I believe so.
Okay. And has he been present at some of their doctor's appointments?
Yes,
You contacted CPS accusing him of molesting the children, didn't you?
I did not.